going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. I'm a little late. I had a little technical issue. My video wouldn't load. I had everything ready. I was on time. The video was just spinning. So I restarted my computer. I apologize, but it's okay. I'm here now, and we're going to have a great night. Hopefully you guys had a great week. It is Friday. Yay, Friday. And you guys, of course, sent me super chats because I was late. Maybe I'm going to be late every night if this is how it happens. Rich, good to see you, my friend. Hey, Cooligans, happy weekend party starty time. Yep, absolutely. Thank you so much, Rich. And Jedi, Colin Starty P, absolutely. Yep, I was expecting that. I was actually expecting it from either you or Phil, but thank you, Jedi. And Phil, yeah, both of you. Both of you. I appreciate you guys. And Wolf Lore Lover became a new member. Thank you so much, Wolf. I appreciate it. Welcome to the family. All right. Now that I'm back, well, now that I'm here and everything's working, you guys want to watch some court? I want to watch some court. Let's watch some court.
I want to watch some court.
Heather wants to watch some court. So, yeah, let's watch some court. I've got two cases tonight. I've got a Judge Ricke case and I've got a Judge Simpson case. The Judge Ricke case, Jill Gillette's getting sued. This isn't new. I think everyone knows it. Yeah, she's being sued by someone that she may or may not have harassed a little bit. I don't know. I don't know the case. I don't know it at all. But this is interesting that we get to see part of it. So we're gonna watch it. Yeah, and then we're gonna watch Judge Simpson deal with a weird landlord-tenant case. That's what we're doing tonight. Isn't that special? I know you didn't just become a new member. Your account's been weird. Because I think this is the third time in a third month in a row it says you're a new member. And I know that's not true. But thank you so much. I don't know what month you're at. I'm going to say, hey, happy 19 months. Because that's just a guess. That's how long you've been around. It's been about that long. Okay. You guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Before I go any further and even announce the case, I just want to check with my court reporter who's on the meeting to make sure that audio and video are good for her.
Yes, sir. Thank you very much.
All right, thank you. Court will call the case at this time. Send the District Court of Elk County, Kansas, case entitled Michael Irvey, plaintiff, versus Jill Gillette, defendant, case number 2025 CV1. Linus Baker appears as counsel for Mr. Irvey. Nathaniel Martins appears as counsel for Jill Gillette. I have individual box on this Zoom meeting. Michael, who is Michael?
Judge, that would be my client, Mr. Irvey.
I just wanted to make sure to clarify that, and thank you for joining with video, Mr. Irvey. I also have someone, Dr. Justin Spees, does not appear to be a party of this proceeding.
He is not.
All right, very well. This is being broadcast on YouTube. I normally don't allow non-party persons to actually join the meeting, so I'm going to ask my assistant to put Dr. Justin Spees in a waiting room. All right. This matter comes before the court at this time on what the court believes to be a motion entitled Plaintiff's Rule 165 Objections and Post-Judgment Motion to Alter or Amend the Judgment, stemming from an earlier ruling that this court had made in the case. The court is aware there's been a response to that motion filed by the opposing party. You may proceed further in regards to your motion, Mr. Baker.
Thank you, Judge. The defendant's motion fails for one simple reason. They filed no affidavit 65320G requires the court to consider the pleadings and supporting and opposing affidavits. Without an affidavit, the movement never carried her initial burden. The California Court of Appeals in J.V. Mahaffey, 218 Cal App 4th, 1522, 1537, 2013, squarely held that a movement's failure to submit affidavits.
No worry, Phil. My computer is not behaving properly tonight either. It's not. It's not. But thank you for saying hi to everyone, Phil. Isn't that special? See, 3 months still isn't right, but thank you. Isn't that special? I do appreciate it. And MB for $10. Thank you so much. Hi, MB. Good to see you. Good to see you. And Nancy, member for 10 months. Good to see you, Nancy. It's been a while. And we love you as well. Hopefully you're well. Okay. We get the gist of what's going on. Joe Gillette's being sued. Well, we don't get the gist of it. The attorney's talking about what's happening right now. So I saw Rob is here. Rob, thank you so much for hanging out with me last night on panel. I do appreciate it. Hopefully you can help us break this down a little bit. So if you're available to listen a little bit, I would appreciate it.
Affidavits with the motion is fatal. And that in the anti-SLAPP is not a mulligan, there are no do-overs. You also stated you would not consider the transcript. That leaves only the pleadings. And the Kansas Court of Appeals in Doe v. Kansas State University confirmed that the anti-SLAPP statute did not alter Kansas pleading rules. Kansas remains a notice pleading jurisdiction.
Yeah, you know what? I've got something privately to tell you, Phil. But yeah, not with, you know what? It's going to be private. We'll keep it that way.
So what does that mean? My well-pleaded facts must be taken as true. Defendants say my petition is filled with conclusory allegations. And respectfully, every legal conclusion that they point to is tethered to a specific fact I pled. So let me walk through them for you, Judge. Retaliation, paragraph 26. I allege that Mr. Irvy's protected speech was motivating factor in Ms. Gillette's retaliation. But this is supported by facts, paragraphs 9 through 13. The duck incident, the public criticism, the media coverage, and then immediately afterwards, Ms. Gillette filed an ex parte stalking petition and threatened criminal prosecution. Those facts provide the sequence of events. The retaliation allegation in 26 is not a naked allegation, but is a legal conclusion that flows from those facts. In paragraph 30, I pled willful and wanton conduct. I pled that Ms. Gillette acted willfully and wantonly with reckless disregard. That too is grounded in facts, paragraphs 18 through 24. She filed a meritless petition. She testified in ways the video evidence disproved. She used the resources of the prosecutor's office to pursue personal vendetta. Those concrete acts show deliberate and reckless misuse of authority. The willful and wanton language gives the legal characterization, but is supported by facts. Lack of probable cause, paragraph 32 and 37. I allege there was no probable cause. That is tethered to facts 21 through 23 and 27. The video directly contradicted Ms. Gillette's sworn testimony, and the court denied her petition. Those are hard facts that put defendants on notice of malicious prosecution claim. As such, the lack of probable cause language is tied to those facts. Malice in paragraph 32, 35, and 36, I pled. The factual basis is again in paragraphs 18 through 24, false sworn allegations, controverted by video, use of her position as a prosecutor for private advantage, pressing forward despite the lack of any factual support. Those factual allegations show improper motive. The malice allegation is not standing alone, is supported by what she actually did. And then the what we call perjury allegations, paragraph 36 and 35, but those are tied to the specific false statements detailed in paragraphs 18.
All right, to break it down just from a high level standpoint, I know Rob, MB, I know there's a few other lawyers here that can break this down more technically. This person that is suing Jill Gillette is saying she essentially abused her position. And Yeah. The attorney is saying that I actually don't remember what I was going to say. I just lost my train of thought. Anyways, Georgia abused her position. She kind of attacked this guy for making public statements, about her, but she used her position's resources to go after this guy. That is what the claim is here. So hopefully, we got that's a high level what's going on. But here, Rob just responded. Anti-SLAPP is a claim that the state is suppressing expression by way of criminal charges. See, I'm close. I'm close. High level. That's what I'm saying.
Through 23. Compared against the video, I didn't just say perjury. I described the precise testimony and show how the video record proved it false. It was more than a label. It's notice of what the testimony, what the evidence supported the claim. So, Your Honor, my petition contains legal conclusions, as every petition must, but those conclusions are not naked. They are anchored in specific facts, the duck incidents, the threats, the misuse of office, the false testimony, the video evidence, and the denials of the petition. That is the essence of a notice pleading. The facts give notice of what happened in the legal conclusions. And therefore, Judge, the petition allegations are all that matters. And those allegations.
So there's an issue with a duck. I'm guessing that is what kind of started this whole thing. We don't know what that is. They're not going to go into details about it. I don't know. But there was some kind of incident with a duck between the two of them. And the term naked just means that, they're not basing this claim on nothing is what why they keep saying naked. I don't know why that's the term he's using. That's the term he's using though. So we're just going to roll with it. Naked ducks. Let's go.
Then provide sufficient basis to deny the motion. There is no affidavit. There is no transcript. And my factual pleadings exceed the notice pleading. And so you have, just with that, Judge, the motion should be denied on those grounds. And so I will leave it at that. If you have any questions, I'd be happy to respond.
No questions at this time, counsel. Mr. Martins, your response.
Your Honor, just briefly in response, I think it's important to emphasize in ruling on this motion that this is, although titled a Rule 165 motion, the gist of it is a motion to reconsider the court's prior ruling. And the case law is clear about the standard that applies to a motion to reconsider. There's got to be a change in the law, which isn't present here. There has to be new evidence previously unavailable, which isn't present here, or there has to be a basis to correct a clear error or prevent a manifest injustice. And so that's what the court's focus is here today, is determining whether or not its ruling was a clear error and would result in a manifest injustice. And as we laid out in the briefing, Your Honor, there's multiple reasons why there was not a clear error, with the most clear and direct being that the Doe case is binding precedent on the court, and it says that the court must consider, can only consider affidavits in relation to ruling on a motion to strike. And because plaintiff didn't present those, then the court was correct in its ruling. There's some additional arguments that were made by plaintiff in the briefing that weren't addressed here today, including the potential unconstitutionality of the anti-SLAPP statutes, which to the extent that plaintiff is still relying on those, we addressed those in the briefing. And I do want to emphasize that we don't consider that a serious argument. I think that's probably evidenced by the fact that counsel didn't bring it up here today at oral argument. Specifically, though, the anti-SLAPP statute is a procedural remedy, no different than like a motion for summary judgment, in that the court is providing just a gatekeeping function and reviewing the evidence in support of a claim. So we don't view that as an issue, and again, counsel doesn't argue it here. And with respect to counsel's comments at the beginning of the hearing this morning with respect to defendant not carrying an initial burden.
Grizzly Old Fart, thank you so much for saying that. It's been bothering me. I don't know why. I can't tell you the last time I saw like a beard without a mustache, or at least a small beard without a mustache. Like he's got about the same hair on his shin that I do, but I have a mustache with mine, and not seeing that it's blowing my mind, and I can't decide if I like it or not. I think I'm going towards not, but it's his style. I'm not gonna hate on his style, but it just looks weird to me. That's it. It just looks weird.
And that's something I did my best to search the briefing here as he was presenting an argument, but that appears to be, in my recollection, is an argument that's being presented for the first time in this motion to reconsider hearing, and it wasn't something that was raised in the briefing either. And as the court will recall from our hearing on the motion to strike and motion to dismiss, there was no dispute that the anti-SLAPP statute applied. And so for the first time in this hearing plaintiff has taken the position that defendant failed to carry her initial burden in establishing that anti-SLAPP statute applied. And so the court can disregard that argument. And so I think the court's ruling is correct based on the Doe case, and plaintiff has failed to provide a basis to reconsider or to change that ruling, Your Honor.
Mr. Baker, Mr. Martin suggests that you're arguing things today orally that you didn't include in your written memoranda that was submitted to the court in support of your motion. Your reply to that?
Well, the idea, I did raise this issue in the hearing. If you recall, we had a great dialogue back and forth about when you ruled that transcripts weren't admissible. I said, well, then you've got the pleadings. Their burden is with the pleadings. I win. I said that at the transcript at that hearing. I said, if all you've got are my pleadings, I win. They didn't sustain their burden. That entire argument was raised with you below in my opposition. They have the initial burden. And so I argued that. You said in that hearing, you said, well, I'm going to look at your pleadings, but then I find that some of them are conclusory. Now, in my motion to you today, Judge, or when I made it, I said, well, you didn't really explain, as I did today, why those are conclusory, that they were just simply naked allegations. You didn't give a factual basis for that. I have tied all those up for you today to say I did make legal conclusions, but each one was tethered to a factual basis. And based on that, Doe doesn't alter notice pleading. It doesn't convert, the SLAPP doesn't convert notice pleading into plausibility or a fact pleading regimen. And so they said, you look at the pleadings. And so that's what you did. I would say to you, Judge, that if you look at my pleadings, they're not naked allegations. Each one of those legal conclusions, as I said today, are tied to factual. And with that, then, with no affidavit, the Mahaffey court said, look, they don't sustain their burden at all. And that's what they relied on. They relied on nothing but that transcript. And so now all you've got are the pleadings. And McAfee says you're not going to sustain your burden if you don't have an affidavit. And they didn't have one. So you're left with these pleadings. The examination of them provide, Judge, and states they don't sustain their burden. And so I raised all these issues in my motion, opposition motion, and at the hearing. We had a great discussion about that. So that's my response to that, Judge.
Is Mahaffey cited fully in your memoranda that you submitted to the court, Mr. Baker?
I don't recall, Judge, but
well, would you go ahead just to make sure? I obviously that's not binding precedent on this court, but it could be persuasive, and I'm curious as to how that court reasoned in that matter. So would you slowly state
Sure.
that citation again?
I will. J.V. Mahaffey, and that's Mahaffey, 218 Cal App 4th, 1522, 1537-38, 2013. And let me, I'll kind of give you a background there, which is in Mahaffey, the defendants filed an anti-SLAPP motion, but did not include any declarations or affidavits with their moving paper. So that's similar to what we have here. But instead, they tried to introduce sworn declarations for the first time in their reply briefs. And the Court of Appeals said, no, you can't eat that. You're done. You can't do it. And so the general rule on motion practice, new evidence is not permitted with in a reply. And because the defendants filed no affidavits, the court found they failed to carry their initial burden under the anti-SLAPP statute. Motions were denied, and the denial was affirmed on appeal. So I think it's on all fours, Judge. And it was a unique situation here because defendants relied on the transcript. I did too. You actually said, well, yeah, let's get the transcript. And then you found the Doe case. And then we were left with no affidavits. But the affidavit part is their initial burden, and they didn't sustain that burden. So I would urge the court to look at Mahaffey because I think it is informative as to the burden shifting in this SLAPP case.
Mr. Martins, have you considered the import of this Mahaffey case in California, which would apparently be construing a similarly worded statute?
Your Honor, no, I haven't. I'm trying to review it now, but I'm not seeing it as cited previously in the briefing, and so this is my first time reviewing it here this morning. And I guess without even reviewing it, the one comment I would like to make, Your Honor, is that the court, as we've discussed, is obligated to consider the pleadings and the affidavits. And I think what makes our situation unique and which allows the court's ruling on this issue to stand is on the face of the pleadings, while the court's not accepting all of the allegations or is not obligated to accept all the allegations in the petition as true, it was clear from the petition that the claims arose out of circumstances, that being a prior lawsuit that would the anti-SLAPP statute applies to. And that wasn't disputed by the parties. And so having that part of the petition and there not being a dispute over it, I think the court is able to accept that allegation as true, or those background circumstances as true, without necessarily accepting all of the plaintiff's allegations, particularly with respect to the more detailed factual circumstances that they allege to support the claim. And that's where the affidavits come into play, and the reason why they need to support that. And so I do think that the court's ruling on it can stand based off of the pleading itself too.
Implicit in your argument, Mr. Martins, is that Gillette had no burden of coming forward with anything.
Correct.
Mr. Baker, I think, disagrees.
I do, Judge. The SLAPP is a burden shifting. They face the initial burden, and that comes through an affidavit.
And what would that affidavit theoretically say, Mr. Baker?
Well, the affidavit say everything you've alleged in your petition is not true. Here are the factual allegations. Here's why it's not true. Things of that nature. And we have affirmative defenses and all those things. I mean, that's why that's why they file an affidavit, is to controvert or say, we've got these other factual allegations that.
Parrot Court, 12 months. Thank you so much for the 12-month milestone. I do appreciate it. I'm sorry I was a little late with the pause. 12 months usually gets an instant pause. I missed that for a second. But I do appreciate it. Thank you so much. Hopefully you're having a great night. It is good to see you, my friend.
Overcome your petition. And that's where I would have to come back if they did that with my own affidavit and then we kind of it's not a summary judgment, but it is that kind of shifting burden. But without that affidavit, they don't sustain the burden. That's what Mahaffey says.
But how would the court resolve that factual dispute?
SLAPP.
We would have competing affidavits, essentially taking an opposite factual view regarding the incidents that are discussed in the petition. How would the court resolve those credibility issues?
Well, you wouldn't. You have to accept my pleadings as well pled. It is not an evidentiary summary judgment kind of issue. So on its face, you have to accept what I've pled and what is said. The SLAPP burden shifting is not a summary judgment kind of thing. And so all you're looking for is
I've got a few of them that I watch. I can start putting them into my my videos a little bit more. There's not a lot that I have, at least. And there's I'm not gonna lie to you guys, there's a lot of Spanish. There's a lot of interpreter cases in California. So I generally skip a lot of the dockets, but if you want to see more California courts, I can implement them more. I can. That is an option. We can do that.
For example, she in her petition, she made many false allegations, completely false, about Mr. Irby going out into the courtroom, outside the courtroom, blocking her car, looking in her car. She couldn't get out, when the video says he did none of that. Many, many false allegations. That is sufficient if you accept that as a malicious prosecution. She had no facts to support what she said. But if you'll look at Mahaffey, the fact they don't have an affidavit, and now you're looking at my well-pled allegations that you have to accept as true. And this is notice pleading. Doe didn't change the notice pleading.
I absolutely do not have to look at Mahaffey as true, because we all know 2 Mahaffeys make a Maholi, and that's the one that's true. So your Mahaffey isn't true. We can't just accept it on the merits. It's not a Maholi.
Into a fact or a plausibility. But my petition does go beyond just notice, just beyond legal conclusions. As I said this morning, I've tied each one of those conclusions into factual allegations. You have to accept that. And my motion urges you to look at that in that context. But they have not sustained their burden. Therefore, no burden shifts to me. They just haven't sustained it. We win. You can't come to the court without that affidavit. Now, that's right. What I think McAfee stands for.
All right, Mr. Martins, I know you want to respond to that.
Yeah, well, I wanted to clarify my position on the initial burden issue is that can also be established by the pleading, in that we don't have an initial burden to present an affidavit supporting anything. And the statute, I think, contemplates that we would be, in a reply, be allowed to submit affidavits responding to factual allegations further, so that the court, because the court is ultimately determining whether or not the plaintiff has shown a likelihood of prevailing on the claim based off of the pleadings and supporting and opposing affidavits. And so that's, I think that's what's contemplated by the statute, not that we need to submit an affidavit in support of the initial motion.
All right. I want to make sure that your position on this is clarified, Mr. Martins. Is it Gillette's position today that the anti-SLAPP statute applies to both claims made in this case? Certainly, the court's ruling, I think, made it clear in regards to the malicious prosecution claim. What about the abuse of process claim?
The anti-SLAPP motion applies just to the malicious prosecution claim. However, there is some overlap in that some of the factual basis for the abuse of process claim were also relied upon by plaintiff in support of that malicious prosecution claim. So to a certain extent, it does apply. It applies to some of the same allegations But I do recognize that the abuse of process claim is a separate claim from the malicious prosecution claim.
All right. Anything that you would wish to comment on based on the court's most recent discussion with Mr. Martins? Mr. Baker?
No, I mean, I just, I think you'll get edified when you look at that Jay Mahaffey case and the burden. So your analysis will first say, did they sustain their burden? And if they don't, they lose. And they.
Jenna, I really have no idea what's going on with this case. I've heard about this in whispers and comments throughout the last couple months. I have not been following it. I don't know. This is just the first time I've seen it on YouTube, and I thought it was interesting, so I'm playing it. Yeah, I don't know what the lawsuit's actually about. Apparently it has something to do with the duck, some naked people, and some McHaffies and McColleys. That's where I'm at. I'm just having a good time. Hopefully you guys are too. But yeah, I have no idea what's going on here.
The motion to strike should be denied. So I think that's the simple equation that I urge the court to look at.
And I think, counsel, we would agree that there hasn't been a whole lot of case law development under this statute. But obviously any California ruling would have to be reconciled with what we do have in Kansas as far as established precedent. And I'm sure you would agree with that, Mr. Baker.
I do. And I think Doe looked to California. A lot of they looked to a lot of California cases. Doe did that. And so Doe didn't stand for the proposition that notice pleading gets turned into something else. And it certainly didn't say, and it does talk about the burden shifting, I think. So, but it's persuasive. And it's not in conflict with Doe. So.
Mr. Martins, would you agree with that?
That is just not.
Well, you haven't had an opportunity. I think that's an unfair question. If you haven't had an opportunity before today to fully review the Mahaffey decision, that's probably not a fair question for you. I'm asking you to take a case that you haven't fully read and processed yet and apply it to Kansas law, which exists. And that's the court's really not going to expect an answer at this juncture. But with that said, this court will be taking the decision today under advisement. The court wishes to obviously review the California case cited today.
Yeah, supposedly that's who Jill Gillette's going after, or who she went after, is a YouTube channel. I don't know. Yeah, that's just a couple comments that I've heard. So I don't know if that's true or not. I have not verified that information, but that's what people are saying.
Apparently for the first time. And then I want to give Mr. Martins an opportunity to file a supplemental response based solely on the application of the rationale of the Mahaffey case in regards to issues which exist in this case.
Understood. Appreciate it.
I think 21 days is a fair period, Mr. Martins.
Yeah, that should be.
You are not required to submit an additional memo of any kind or submission of any kind. But if you do, that needs to be on file within 21 days of today.
Okay.
All right. Mr. Baker, anything further at this time?
Thank you for your courtesy, Judge, and letting me appear by Zoom because of those other circumstances. Very courteous of you to do that. Thank you.
You're quite welcome, Mr. Baker. Anything further at this time, Mr. Martins?
No, just for clarification on the record, I think we're all on the same page on this. We did file the motion for attorney's fees as well under the anti-SLAPP statute. Obviously, I think we need to resolve this motion first. And so I guess just to make the record clear that we'll reserve that for argument. That's
so noted, counsel.
Thank you.
Very well. Have a good day, gentlemen.
Thank you, Judge.
Thank you.
Nothing further. This matter will currently be in recess at this time.
All right, well, that was fun. That was a great way to start our weekend, wasn't it? You know, I think we all had fun with that one. I think maybe only like 3 of us actually understood what was going on there, which is fine. You know, Rob, MB, you know, you guys help us keep the channel going. I don't know. The thinnest skin, Gillette or Webster. I don't know. I'm not gonna. I don't know. I've seen both of them at very vulnerable points, getting very frustrated over dumb things. So I think it all depends on what day of the week it is, who has the thinner skin. But yeah, Miss Jill has she's exposed herself a few times online, and so has Judge Webster. So I'm just gonna say depends on what day of the week. I'm gonna keep it safe. All right. See, I mean that was kind of my answer. That was my answer. Depends on what kind of day of the week. Anyways, we're moving on. We've got a Judge Simpson case. This one is just weird. It's a landlord-tenant case. This is another one. We're going to actually know what's going on here because it's not that confusing. It's just weird. It's just a weird Friday. Let's go.
Court does call the case of the estate of Earl Samuels II versus Jonathan Samuels.
Good afternoon, Your Honor.
Good afternoon. Your names, please.
Jonathan Samuels.
All right.
Steve Magus, Your Honor, attorney for the personal representative of the estate of Earl Samuels, Tim Flynn.
Okay. Couple of things, and the reason that the court set this hearing. We have checks in place to try to make sure that documents aren't filed. I'll say in violation. I'm not saying that using the word that it was intentional necessarily. All of which includes the court officer, all of which seem to have not taken place. But the question for the court is frankly, I don't know that this writ should have issued in the fashion that it did. Maybe for not, but ultimately, but it should not. First question I have is the documents we had indicated that the writ was executed.
Yes, Your Honor.
Okay.
Without any notice.
Well, there would have had to have been notice because there should have been 72 hours notice.
They put a notice on the house, but he knew that at the time I wasn't staying there. He knew where I was. He didn't email me or
Who knew?
Attorney Magus.
Well, all of the orders of eviction which I sign and send out, and I'm the one that does it, there's a 72-hour posting. So it's posted, it won't be executed for 72 hours. Are you saying that didn't happen?
I imagine, no, they put a notice on the door when I saw it, when I went there afterwards, that the notice on the door was dated more than 72 hours before the action that they took. So they did that, but the point is, Attorney Magus has been in communication with me about a lot of things. Deliberately didn't tell me they were doing this. He deliberately didn't tell me they were towing my cars. It's representative of how everything has gone and his lack of respect for my devisee ownership right, and the fact that I told him from the first moment I talked to him, now nearly several months ago, that buying the farm was the most important thing to me, and he's done things which have very much hurt me and my ability to follow through on that. So this is just one of, he also locked me out of the house where I was staying at the time on June 30th, my parents' house in Farmington Hills, without notice. So he has a pattern of doing things just that are easy for him. And then he tries to say I wasn't staying there all the time, even when, as he saw, my things were there, my food, my computers, my documents, I mean, so and now they're saying that I never lived at the farm. I did live at the farm in the past. I mean,
There's a There's a big story here that we could take up the rest of your afternoon, and then some with regard to the administration of Jonathan's parents' guardianship and conservatorship, and now their probate estate. I'll try to keep it on the main points that relate to this case. The property that we're talking about here has been approved for sale by the Oakland County Probate Court.
Got it.
Before the probate estate of Earl Samuels was involved, a judgment was issued that advised Jonathan, I think it was the end of 2023, that any personal property that he wanted to remove from the property, he needed to remove by, I think, the 12th of December, 2023. We had several of these judgments with regard to estates and properties, okay? And I applied for orders of eviction on all of them, just to simplify the contingency that Jonathan has a pattern of anytime we try to sell a house, he says he lives there and he moves in. So I learned thereafter about there's potentially a court rule that says it has to be 56 days.
Yeah.
It wasn't that intentional. It wouldn't be the first time I've learned in real time about a court rule. But the reality is Jonathan doesn't live there, and he's using this as an opportunity to effectively appeal the probate court's decision to allow the sale.
Which was based on misrepresentations, many of which by Attorney Bacchus.
All right,
I believe,
so I'll let you talk, sir, but I'm not
I'm sorry, Your Honor.
going to have parties interrupting. Let me just say this, I'm not going to get into anything that the probate court does. If I wanted to be a probate,
None of your business. Thank you so much for the generous super chat. I'm extremely late, so here's one fee. And oh, hold on, I gotta scroll down. And I'll rewatch this tomorrow to get what I missed up. A great night and have a great weekend. Thank you so much for the super chat. I appreciate it. Another squid with 5 gifted members.
court judge, I would have done it. So I'm not going to do that. All right. The issue that I have in this case, and like I said, there are a number of checks in our system, all which failed, is that
All right, what about now? Can you guys hear me now? Can you hear me now? Well, yep. Heather had to just run in here and pull my headphones off because my headphones just decide to stop working every once in a while. Let me start this whole speech over again. So we're gonna start with none of your business. None of your business. Thank you so much for the super chat. I appreciate it. I'm extremely late, so here's one fee, and I'll rewatch this tomorrow to get what I missed. None of your business. Always good to see you. Hopefully you're having a great weekend. Thank you so much for the super chat. Another squid with the 5 gifted memberships. Thank you so much. Another squid. Welcome to the 5 new members. Another squid. You are awesome. Eileen. Super generous, super chat. Thank you so much. Reward for apprehension of kidnapper. I don't know what that means. I don't know if I missed something. I don't know. But I do appreciate the super chat. Thank you so much. That is extremely generous. Thank you. Thank you. And B, mic fund. You know what? I think it's time. I keep saying I'm going to buy a mic, and I have not done it yet. I got to buy a real professional mic. I bought this headset. It wasn't cheap, and I bought it, and it worked great for about 6 months, and it's just slowly dying. I just don't understand. But MB, thank you. And Jedi, thank you so much. New headset fund. All right. Yep. Okay. New headset fund. Looks like it's happening. Jedi, thank you so much. You guys are awesome. Thank you, everybody. I can't put into words how awesome you guys are. But someone stole kittens. Oh, I got you. All right. Why are people stealing kittens? First and foremost, why are people stealing kittens? Then why are they stealing Cheshire Cat's kittens? I mean, We need to put Mr. Allen on this. Is what we need to do. Mr. Allen will come to the end, figure it out. He's going to be our new Chuck Norris. You know how we have all the Chuck Norris jokes? We're gonna turn all those into Mr. Allen jokes. You know, sharks have a week dedicated to Mr. Allen. I don't know if you guys know that, but that is true. They have a week dedicated to Mr. Allen. Okay, let's go. Let's continue the case.
There would have needed to be a hearing prior to the issuance of the writ. It becomes a little bit more concerning based upon the documentation that I received today and reviewed that.
Thank you, Kurt. Thank you, Kurt. I do appreciate it. Awesome. Mike Fund. I'm guessing that's what that is. Mike headset money. Yeah, Mike Fund. I appreciate the super chat, my friend. Thank you.
The defendant does not reside at that address. That's what I received today from, I think, the individual who is the conservator of the estate or the personal representative, which maybe means that the issue is moot or maybe not, because, sir, you're claiming you reside there.
I'm claiming that I resided there in the past, that there's things of mine there, and that they still need to go through some process because I.
Oh my God, can we start this? Can we start a thing? We're going to do Mr. Allen jokes instead of Chuck Norris jokes. Can we do that? I'm pretty sure all of us together can put up some good ones. So then the next time that I go to Judge Simpson's courtroom, I can give Mr. Allen the jokes. Ah, that would be awesome. Yes, let's go. I used to know a lot of Chuck Norris jokes. Fun fact: when I was in my very first database management class, we had our final project was we had to take a big data set and do something with it. That was literally it. We had to take a big data set and do something with it, and the data set had to be at least 10,000 lines of data. And I was able to find a text file of over 100,000 Chuck Norris jokes, and I wrote a program where all you had to do was type in a word, and it would just pop you up a Chuck Norris joke using that word. So, so good. I need to go see if I can, if I still have that text file, that'd be awesome. Parrot Court. Okay, I'll pitch in too for the mic. Oh, thank you, Parrot Court. I appreciate it. Thank you. Okay, let's keep going. We're watching court. I'm getting distracted.
I have rights, because especially now that there is an estate and I'm a 50% devisee, that they can't just, without any notice, decide to try to have something enforced that's actually a totally separate action. Nearly 2 years ago, it's obviously no longer the conservatorship, and I didn't have any ownership right then. So it's, the law is actually that ownership passes at the time of death. It's just subject to administration, and then it gets backdated, sort of. So I have a legal interest that I did not have in the farm almost 2 years ago. And in fact, I told, as I say, Attorney Magdis how important it was. And he refers to me not moving things out. Well, what I told them nearly 2 years ago was I was determined that the farm wouldn't leave the family. So Dad didn't want it to leave. He had testamentary capacity. All of this has taken place because people don't respect even the proper procedure.
Sir, I'm just gonna stop you because you're getting into issues of which this court doesn't have jurisdiction over.
Right, but it did have the.
Amy, thank you so much. I've actually been to Judge Middleton's courtroom. I met him in person. I talked to him on the phone once. He is the exact same person off of YouTube as he is on, and I think that is the biggest compliment I could ever give somebody. There's someone who doesn't change, who's just the same person, and but yeah, Judge Middleton's awesome. I've got a couple shout outs from him. where he's mentioned me during his streams, but he was really nice. Him and Debbie Davis are amazing people. I need to get back there. It's so far away from me. I say that now kind of funny because I drove to Halifax, and Judge Middleton's about 4 hours from me. Halifax is 24, and I did this drive, and I'm saying and what is it? St. Joseph County is too far away. Anyways, but yeah, no, Judge Middleton is awesome. He really is. Phil, very generous super chat. Thank you so much, Phil. Heather, make sure he gets a good one. If you put Heather in charge of the headset, she will absolutely make sure I get a good one. Phil, thank you so much. I do appreciate it, my friend.
Well, and there's actually some question of whether it even has the authority to evict someone in a situation like this. Some things that I was studying today, and I actually filed something additional with the court because of my ownership interest as an advisee, that it's not even necessarily subject to the same landlord-tenant eviction procedure as Attorney Magdis had.
I will most likely still be in Canada. I want to stay here through their Thanksgiving, which is middle of October. So that's the plan. So I doubt I'm going to be home for that. So you're gonna have to report back to me and let me know how it goes.
Enforced inappropriately. So it's complicated, and Attorney Magdis and now my sister's attorney want it to be simple, and it's representative, as I was starting, of many things that have happened over the past 4 years, because my parents were clear on what they wanted. My dad was clear on what he wanted for the future, and for the farm to be sold like this is horrific. And the fact that
But sir, just stop for a moment. The sale of the farm, as you're indicating, again, is not something that is
Right.
within my jurisdiction.
that was my next sentence, but your signing this order was an essential step in them selling the farm now. So
And it may very well be, but what they do with the property after an eviction, I'm not part of it. I don't know. On the numerous cases I've had today, there are eviction orders that are issued. What then the owner or the person in charge or with authority over that property does, I don't deal with.
of course, Your Honor, I'm just asking for you not to issue an order of eviction in this case, especially because there's multiple reasons not to issue it. Both the fact that, as you say, they didn't follow the regular rules the way they're supposed to, initiating a new proceeding if they were going to argue that eviction was the way.
Well, they wouldn't be required to issue a new proceeding. There would need to be a hearing prior to the issuance. But then the information that I've subsequently received may have the ultimate result of that be moot. Because the real issue is at the point, there's a time limit from the point of the judgment to the issuance of the writ, and then how long the writ then has to be executed. There are 2 56-day periods. Here, the first one, in terms of having.
Oh, the best part about the Mr. Allen jokes, he's off today. He's not even there. I don't know who that is, but that is surely not Mr. Allen. You can tell by 2 things. One, his fair complexion, and 2, the lack of hair. Yeah, not Mr. Allen. But I love this. Rob, you were killing it. Also, Phil, Heather's been shopping for a new mic for the last 20 minutes. So, yeah, sounds like I'm getting a new mic this weekend.
A hearing wasn't complied with. The question becomes, at least in my mind, is do I order you restored to the premises or do I not order you restored?
I would say it's simpler than that to just vacate or stay your eviction order because there's,
Can I just say this? By what you're telling me, and I don't know this for sure, but certainly the information that I received was that you were not residing at the property.
not,
Things you're saying to me right now lead me to believe that you weren't residing at the property and that there really hasn't been any harm by the execution. Because you keep talking about something that has occurred as though it hasn't occurred.
no, they definitely caused harm. They already towed my vehicles. They broke into the house. They didn't give me any notice that I needed to work to remove, because they're actually, even though the house, I mean, there's things of significant value there that Attorney Magnus is not aware of.
If it's helpful, Your Honor, with regard to the substance past the procedure, he can have everything in the house. It's a hoarder house. You can't even open the door. It's actually dangerous, which we're a little bit worried about, but if he's willing to waive liability, he can go in and take whatever he wants. What we're trying to avoid is him getting back in there, claiming he lives there and stopping the pending sale.
Okay, so let me just say this. Although the eviction was executed, there was property that was not removed from the premises as of yet.
The only property that was removed from the premises is 2 derelict vehicles that were towed and are available for Jonathan to pick up.
Okay, but those were on the outside. Those were on the premises, but not inside the house.
Yes.
But as far as things in the house, nothing was removed.
Nothing was removed from the property.
Okay,
That's not true.
makes it
They
easier for me.
threw things out on the front yard. They took some things. I mean, I wasn't there, but it looks like they took some things away. Because they scattered stuff on the lawn and out by the curb.
Here's what I'm going to order at this point to try to.
You know, I read Mr. Allen's diary once. It was a great book. They actually changed the name of it now. It's not Mr. Allen's diary. It's the Guinness Book of World Records. Yeah.
Correct the 56-day issue, as well as to try to address whether or not then there's sort of this clear path to the estate doing what it wants to do. I'm going to set a hearing. So while it's after the fact, the very fact that things have not been removed is fine. My determination will be whether to allow the execution of the writ to stand. And in that respect, the property inside, you can let him in or not, if that's the way I rule. Or that you would at least for a time period be restored possession of the premises subject to the hearing and then the court's issuing of a new order of eviction. And that's the best I can do to kind of remedy the circumstance. Quite frankly, it's a little bit easier than I thought because stuff hasn't been moved. So it's easier in that respect. It's also maybe easier in a certain respect. I don't think you were residing there. So it's not like I took. Sir, please.
I'm sorry, Your Honor.
It is not as though there was a, for lack of a better term, a household that then is completely taken out, and this is a different scenario. So we will have the hearing, and I will either allow the execution to stand or put it back in. That's how I'm going to.
Oh yeah, I forgot there was actually a court case going on. I was having too much fun with the Mr. Allen jokes. Yeah, so this guy is kind of a squatter-esque type of guy. He has some kind of relationship with the owners of the property, being a family member that has passed away. So the attorney here is representing the what is the executor of the I can't think of the right title. I'm sorry. But the executor of the will, essentially, and this guy is squatting on a property so they can't sell it. Essentially what's going on. They issued a writ to kick him out, but they didn't go through the proper steps to do so, which caused a kind of like a little clusterfuck at the beginning of the case, and they're working through that now. This guy is hard-headed, and he's being difficult on purpose. That's what's going on in this case. Judge Simpson knows it, but he can't say that. The attorney knows it, but he can't say that. But I don't know, the wannabe tenant / squatter, he just asks a bunch of dumb questions. That's all. That's pretty much what happens in this case. All right, we can all go to bed now. All right. No, we're gonna finish this one up. You guys are awesome.
Handle this. And so when's my next
The
available?
time issue though is
I'm sorry, sir.
that I would have, if he would have followed things, I would have had more time to deal with. There's things there that would take me some time to move.
But sir, okay, let's just go with your hypothetical.
Did you guys know that when Mr. Allen works out, that the weights he lifts, they're the ones who actually get in shape? Yeah, facts.
Had that happened, they would have requested a hearing because it's afterwards. Let's say at that end of that hearing, I permit the issuance of the writ. Okay, just hypothetically, let's say we had gone through that whole process. And let's say they brought their $15, they brought the writ or the order of eviction in, I sign it that day. They get the officer to go out there, post it. You're going to have the same time frame. You're going to have those 72 hours prior to then the execution of the writ. So in terms of your argument regarding time, it's not an argument for the court.
Wouldn't there have been time before the hearing that I would have been notified of the upcoming hearing?
Right.
So that's the most significant time. Because
Are you listening to anything I'm saying?
I definitely am. You said that the order of the writ would be 72 hours, but I'm talking about before that, before you would potentially issue the order, the time between being notified of the hearing and actually having the hearing. And I don't know.
Okay, so here's what I'm going to do. Listen real carefully. I think counsel gets what I'm doing. I'm going to set a hearing. Normally what the hearing would have been, had it occurred in its order, would have been a determination as to issue the writ or not. I will set that hearing, although it's seemingly after the fact, there isn't much harm or any harm because I don't have a household that's displaced. What I really have is a circumstance where they've taken possession of the premises. Things have not been removed. And then I will make that determination as to whether or not that writ will stand or it will not stand. You follow that?
Yes, Your Honor. I just thought that there's requirements of notice before such a hearing.
I am about to set a date and that will be.
That is the best. That's the best one of the night. With a threat at Mr. Allen, Magoo got a public defender. Absolutely. Oh, at least that one made me smile. Thank you, Ginger.
Your notice.
And what would the date have been if they just started prep?
Sir, yeah, okay.
I'm sorry.
I'll
No, it's not a bank. This is an attorney for the executor of the estate. So I'm guessing it's the older sibling or it's the sibling that was left the property to. That's what makes sense. That's what best makes sense to me. This is the first hearing I've heard in this case, and they don't give a lot of details about the overlying case. It's this guy lives on a property that he's not supposed to be living in, is essentially it. Rob. Ginger wins. Yeah. Mr. Allen scares soft sits into getting public defenders. Yeah. I don't know if you can beat that one.
I'll give that to you. Hold on one moment. What's my next 16? Okay. So here's what I'm going to do. I'm going to set it for the 16th. Okay. In person at 9 a.m. Now we're on the 5th. So that gives you now, from the court's final ruling, 11 days. So your question is whether or not that in some way penalizes you. Actually, you benefit from it. Because had they filed the motion or the request for hearing prior to, had they mailed it to you, they could have had a hearing in 9 days. If they had personally served you, they could have had a hearing in 7 days. Here, that's the notice you would have gotten. Here, you're getting 11 days.
Okay, Your Honor, but would that have been a hearing based on the previous filings? Because that's my basic contention.
Previous filings of what?
That led to your judgment in December of 23.
I don't know what that means.
They're attempting to continue something that isn't. So I'm not sure.
Hey, Parrot. Good to see you. Have a great night. And yeah, don't be a stranger. It was really good to see you tonight.
How the procedure would work if they didn't have the December of 23 record and
You are truly not following this, are you?
I'm sorry, Your Honor, I'm just thinking.
No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Because what I'm telling you is that on the 16th, I will make a determination as to whether or not the writ stands, or whether or not that writ is then the execution thereof is squashed and you're restored possession of the premises.
Okay, thank you, Your Honor.
That is the same decision, quite frankly, that had they filed the 56 days and had they filed for the hearing, that is basically the same determination that I would have been making. Could they have the writ, or do they not get the writ for whatever various reasons, may have to do something else?
What's the reference to 56 days? That's what I don't understand.
There are two 56-day periods in landlord-tenant law. First is that a judgment must issue within 56 days of its rendering. Has to be signed. The second is that a writ, well, actually, that first one isn't really necessarily a 56-day. After the judgment, the writ of restitution or order of eviction cannot issue 56 days, more than 56 days after, without a hearing. And then once that issues, that the second 56 days is that writ must then be executed within 56 days of
it's that's what I didn't understand. Okay.
All right, guys. This just in, breaking news. When Mr. Allen goes camping, ghosts tell him campfire stories. Facts. True. It's all facts.
I thought it was a after. It's a within. Okay.
What's a within?
The 56 days that you refer to are periods within which something must occur. I thought they were periods after.
Okay, so that I'm not going to sit here and go into some huge legal argument with you.
Okay.
It's the 56 days where things can happen automatically without court intervention. Let's do it that way.
Thank you.
All right. So.
Yeah, I can't unsee that now. Thanks, Phil. I absolutely cannot unsee that now.
While that happened in this case, I am in the writ was not executed in its traditional sense because things were not removed from the premises. And I will take counsel's representation as an officer of the court. That has not occurred. So then the question becomes, really, just to break it down to you, make it easy. I'm going to have the hearing on the 16th for a determination as to whether or not I allow the order of eviction to stand or whether or not I vacate it.
Thank you, Your Honor.
So I will set that hearing September 16th, 2025 at 9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior.
Yeah, that was an accident. Hold on. I was looking to see how much time was left, and I fast forward to the very end of the video. We're at 50 minutes, so I'm just gonna go back to 50 minutes. Yeah, this is a good spot. Someone just said something. I'm behind the first case. You can see the background on Gillette case on Lawrence Accountability. Okay. All right. If you guys want to check it out, there you go. Lawrence Accountability apparently is the channel where we can find out the information on the case. Okay. Sorry about that, guys. I fast forwarded for no reason. Yeah, let's there's only a minute of this left, so let's finish this one up.
On the 16th for a determination as to whether or not I allow the order of eviction to stand or whether or not I vacate.
Thank you, Your Honor.
So I will set that hearing September 16th, 2025 at 9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior to that time. And I will also review what I need to at that hearing and make my determination. Thank you,
Things
Your
will
Honor.
still be here, or will eventually you be in Saline?
Pardon?
Things are always going to be here, or will you eventually be in Saline?
They will always be where I am. So I am here. So it will be here. I will let you know that on the 16th, it won't be in my courtroom, courtroom C, it'll be in courtroom A on that date. Because it'll be
You're always here. Some things are out of the 14A4 in Saline.
14A4 hasn't been open for almost a year now. So,
Okay, I'm unaware of everything. I'm sorry.
okay,
Should I prepare an order, Your Honor, or will the court? Thank you.
we're good. We'll have to hear. All right, thank you.
Thank you.
Phil, that is a great question. Where am I going? Well, when I restarted my computer at the start of my stream, I didn't open up my tabs. So it might take me an extra second. That's all I mean by that. Let's see. It's Friday night. We got Booze and Body Cam tonight. It's probably going to be one of them. Let's just see who's available. Customization, tabs, redirect. Yeah, click so many buttons. KFAR, KDZ, Lone Wolf. Those are the three options we have. See, I've already rated Lone Wolf, I think, twice this week. I have not hit KDFAR. Yeah, don't say that. I'm not gonna. Don't. that sounds bad. Let's go to KFAR. Yeah. Wow, I can't believe I said that. Let's not start that rumor. That rumor is not going to start. That sounded weird. It sounded weird coming out of my mouth. It was an accident. All right, we're going to KFAR. That's where we're going. Thank you everyone for the amazing night. I hope you guys had a great night. I had a great night. I had a lot of fun. The Mr. Allen jokes were hilarious. You guys are awesome. Mr. Allen can hear Braille. Mr. Allen can hear Braille. Yeah, like they keep coming. You guys are absolutely awesome. Thank you guys so much for the super chats, the gifted memberships, the membership milestones. Mods, you are awesome as always. Have a great night, everyone. Have a great weekend. I am off tomorrow. Tomorrow night is date night, and I get to go on an official date night tomorrow night, and I am really excited about it. I'm taking Heather out to dinner. Don't tell her, but it's a surprise. Yeah, I'm really excited about it. So that's tomorrow night, and then so I'll be back Sunday night. But yeah, that's it. That's all I got. I'll see you guys Sunday night. Go tell KFAR that I said hi. But yeah, that's it. That's all I got. Did you get any walleye? I didn't get any walleye yet. No walleye yet. No, I had salmon for dinner tonight though. I had salmon for dinner, so it was good. Yes, Yes, that would happen if I tried to raid Mr. Allen. It would fail instantly. All right, you guys are awesome. Don't tell her. Yeah, don't tell her. She's not listening right now. She's in the bedroom, so she's not listening. Don't tell her. Don't tell her I'm taking her out tomorrow night. Shh, shh. Okay, you guys are awesome. Go tell KFAR and Katie Z I said hello. I'll see you guys Sunday night. Until next time, bye.
Yes, it is. Good things in recess.